This is extremely worrying. In a case out of the 10th Circuit involving Glock switches and machine guns, a federal court just decided to ignore the Supreme Court to uphold gun bans. This is a really big deal, and here's why it matters. In the most significant Second Amendment Supreme Court decision in decades, Justice Clarence Thomas, writing for the majority, ruled for any gun control law to be constitutional, a two-step test must be satisfied. This new standard fundamentally changes the way that courts are allowed to regulate our right to keep and bear arms. And it is really important that you understand how this works. First, the court must decide if the regulation does in fact implicate the Second Amendment. If it does, it is presumptively unconstitutional. In other words, anything involving the American people keeping and bearing arms is allowed by default. The second step, though, is where this typically gets complicated. The second step of the Bruen test, which is what this case was called, asks the following question. Is the regulation at issue consistent with America's historical tradition of firearms regulation? If not, the law is unconstitutional. In other words, if the government cannot prove that there was a similar law at the time of the founding, the regulation is not allowed. Let me be clear, this test is a massive win for the Second Amendment. It was one of the best things to happen to our right to keep and bear arms in my lifetime. Here's the thing though, none of it matters if a district court just chooses to ignore it. And that is exactly what happened, and we're gonna talk about it today. Before we do that though, if you are new here, please make sure to subscribe down below. I really appreciate all the support so far, and yeah, let's get into it. Again, this case is about machine guns, but that's not really the point. First, we're gonna talk about the case and why what happened was so significant, and then we're gonna talk about where I see this going in the future. So what actually happened and what did the district court rule? So this guy called Tamari Morgan was arrested in a routine traffic stop, and during that stop, they found that he had a Glock switch, which essentially lets a Glock fire automatically, and an AM-15 modified machine gun. He was indicted for possessing a conversion device, in that case a Glock switch, and a machine gun, and this case was actually thrown out by the district court on Second Amendment grounds. This was clearly the correct decision. At the time of the founding, there were no laws regulating machine guns. The founders knew about weapons of war. From battleships to cannons, they allowed civilians to have and possess these items. Because of course, that is central to the message of the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The point of the Second Amendment is for an individual right to possess guns that can protect the United States from tyranny, both domestic and foreign. It is very clear that machine guns and cannons and battleships and everything like that fall under this. So it makes perfect sense why they ruled that way. Remember back to the earlier part of the video where we talked about the two-step test. The first step is clearly satisfied. There's no doubt machine guns are a type of arm, and so the Second Amendment, the right of the people to keep and bear arms, is clearly implicated. Now, of course, maybe there's a historical tradition, but again, that in this case is not satisfied. So under the Bruen test, you should be able to possess a machine gun. There is no doubt about that. But then something crazy happened. The US Court of Appeals upheld his conviction. But here's the crazy part. Their argument wasn't that there were historical analogs. Obviously there aren't, right? At the time of the founding, there were no historical analogs. There is no tradition of firearms regulation in that manner in America. You know that's true, by the way, because up until 1986, I could just buy a machine gun. I could have a machine gun, you could have a machine gun. There is no historical tradition of regulating that kind of firearm. The district court though, the Court of Appeals, didn't hold that there was, right? That might be an argument, maybe you pick out some law from one county and kind of try and justify it. No, that's not what they did. They instead ruled, and I'm kidding you not, that a machine gun is not a protected arm under the Second Amendment. That the Second Amendment doesn't even talk about that kind of arm. That was their argument. I kid you not, that was their argument. Now, obviously, they're being cynical. The court thinks that that doesn't implicate the Second Amendment, and it obviously does. This is a slap in the face to the Supreme Court. So what do I think the Supreme Court are going to do about it? I think this is the important part of the video, and it is speculation for sure, but I think I have a pretty good read on it, and to be honest, it's not good. I hope I am proven wrong here, but I do not think there is the appetite currently on the US Supreme Court to do anything about machine guns at all. I don't think the NFA is going to get repealed, and I don't think the Supreme Court is going to step in to do anything about machine guns. I think it's highly unlikely. First of all, even though machine guns weren't fully restricted in civilian use up until 1986, there was some laws on the books. The NFA did exist since 1934, and I don't think the Supreme Court has the appetite to overturn that. Even the conservative justices, typically, unless they can avoid it, will just rule the way that things have been. They're a pretty status quo organization, to be honest. Let me be absolutely clear though. The NFA is a joke law, and current Supreme Court precedent means that this is unconstitutional. I'm not gonna mince words, I'm not gonna say anything about that. Now again, it is not our priority But it is very, very clear the $200 tax is just a workaround to get under constitutional limits, and I think the justices probably know this, and they probably to some extent agree. Here's the thing, if you look at what the NFA restricts, it makes no sense, none at all. Obviously we have the machine gun issue, which is really 1986, where it just effectively blocks the machine gun, right? It was amended in 1986. But you look at 1934, it's like $200 tax on suppressor. It is so insane. That's just hearing protection. Or if you look at like the short barrel rifle thing, that's even crazier. I mean, that is wild. Okay, so we have legal, right? With the same ballistics, I can have a pistol. That's legal, 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 legal. Illegal now because it's a rifle. Illegal, 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 legal, 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 legal. It's wild. It is unbelievably illogical. It makes no sense, and you cannot find a compelling constitutional reason for it. It is very, 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 very clear that these are constitutionally protected arms. The Supreme Court knows they're constitutionally protected arms, and in this case, a district court just decided to ignore them. Now, will the Supreme Court correct them? No, but this district court just said, screw you, basically, to the Supreme Court. This Court of Appeals just said, screw you to the Supreme Court. They just said, I don't care. I don't care what you say. I am just going to make up my own laws and just ignore the Constitution. There is no doubt that's what happened in this case. Now, it's not going to get corrected, but that is what happened. And it's very, very clear. If you look at all current Supreme Court precedent with history, tradition, in common use, anything like that, these are lawful firearms. They're very clearly firearms that can be used for lawful purposes by regular American people. And they're not like particularly dangerous or unusual. They're presenting the same danger that regular firearms do, from short barrel rifles to sawed-off shotguns to suppressors. Any of these things do not present a heightened level of danger or unusualness. They're simply arms that, let's say in the case of a sawed-off shotgun, have been modified slightly, or in the case of a suppressor, are just less loud, so I don't know, kill my hearing. It's totally insane. It's totally unreasonable. And there is no reason why we should stand for this long term. You cannot provide me with a reason, and if you have a good reason, put it in the comments, but you cannot provide me with a reason why a pistol with a vertical foregrip should be a felony. It's just insane and arbitrary. The Supreme Court knows this. Again. They are aware of this, they know this. The district court is aware of this, and they know this, and the district court decided to ignore it, and the Supreme Court's not going to enforce it, and that's just the reality. The NFA doesn't affect that many people, and there just isn't a political appetite for it. If you look at Second Amendment organizations, on principle, yeah, they're opposed to the NFA. There's no doubt about it. But most of the cases they advance and most of the issues they try and push are typically much broader. Think sensitive places, specific gun bans like AR-15 bans, and things of that sort. There isn't really the appetite to overturn it because no one has a machine gun. No one's machine gun is being currently taken away because they don't have them, right? It's the same with short barrel rifles, sawed-off shotguns, things like that. There isn't really the appetite for it. Suppressors, you can argue, maybe falls into a different category, but in terms of the sort of more unusual firearms covered by the NFA, it's unlikely we're going to see any movement on that. I, for one, personally, I'm as principled a Second Amendment guy as you find, right? It's not my priority, legislatively or otherwise. The reason is there's so many other issues to deal with first that we're not probably going to make it there, at least in a long time. The Supreme Court justices, by virtue of them having been judges, are very law and order focused people. That makes sense, and that it honestly is reasonable. And so to them, these weapons are typically possessed by criminals because, shocker, if you lawfully can't have them, right? So it makes sense that typically they are just possessed by criminals. And so because of that, there's a strong association built up between these arms, which definitely implicate the Second Amendment, and unlawful activity. And so to a large degree, the justices, just by inertia, just by the way that their thought patterns work, are very, very unlikely to want to tackle this issue. Now that is regrettable, and of course, if I was on the Supreme Court, you know how I would rule. But the reality is, no Second Amendment organization and no Supreme Court justice is going to push for this to be taken. It just doesn't make sense in our current political climate. Same with Congress. Congress is probably not going to touch the NFA, other than reducing suppressors maybe and potentially SBRs. But it's very unlikely that they're actually going to mess with it too much. And so I don't see much progress that we're going to get here. This, in my view, is going to be one of those issues that, unfortunately, for a long time, your rights will be violated. And I know justice delayed is justice denied, and that is unfortunate. But I think largely, even though the district court is just blatantly ignoring the Supreme Court, I doubt anything will come of it, and I doubt judges will face any consequences or that much will change. I know that's unfortunate, but that's just the way I see it, and I'm just calling balls and strikes here. If you do disagree with me, leave a comment down below. I would really love to see an angle that you think we can attack this on. But personally, I don't see it. I hope you did enjoy the video though. If you are new here, I'd really, really appreciate a subscribe. We've been going really quickly right now, and so thank you to all of you, and it really, really means a lot. So if you are new here, please subscribe, and I'll see you in the next one.